The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 3 cases that will be submitted, and those cases are Michael Jones versus State of Iowa, Roy Karen, Peddler LLC versus Elliott Aviation and others. And the final case is Marcus News, Inc. versus O'Brien County Board of Supervisors and Iowa Information, Inc. That last case is now submitted to the court without an oral argument, and we will proceed. We'll proceed to hear the arguments in Jones versus State. Mr. Nieman.
Good morning. May it please the court, counsel. My name is Nate Nieman. I represent the appellant applicant Michael Jones in connection with his appeal from an order granting the state's motion to dismiss in the district court. I think that this case can be decided on 2 grounds, one broad and one narrow. The broader ground would be determined that plain is not retroactive or that it is retroactive. The narrower ground would be to determine that the district court exceeded its scope in determining whether the application failed to state a claim for which relief could be granted and dismiss the petition on improper grounds. And I think that it's important in determining whether to reverse this case or affirm based on the broader or narrower grounds to go over briefly the procedural history of the case, just to sort of give the court some background as to how this case got here. So Mr. Jones filed a pro se petition arguing a jury composition error under plain.
Isn't there a third way to dispose of this case? Dealing with the prior, in a prior post-conviction relief action, they brought an action that the jury was not a proper cross-section, but they applied Jones, they didn't apply plain, and the court in that decision found there was no, the third element, there was no systemic exclusion of blacks from the jury. That has to be res judicata, the law of the case, because, you know, even if we had the second element and applied plain, you still lose.
Well, Your Honor, respectfully, the appellate court decided a different issue in that case. In that case, it was an ineffective assistance of appellate counsel claim. And in this case, it was a due process, equal protection, and not an ineffective assistance claim. And therefore, because it wasn't the same claim that the court was deciding before, res judicata principles wouldn't apply.
But if it's not systemic under a Jones analysis, how is it systemic under a plain analysis?
Well, I don't think that necessarily has to be reached because they're different claims that the applicant was making in the first case and the second. And if the appellate court was ruling on an ineffective assistance of counsel claim, then that's going to be a different analysis than this court ruling on a due process, equal protection.
But for both claims, one of the pieces you have to show would be that third prong under Durant Plain, the systemic or systematic exclusion. And that has already been litigated. Court of Appeals said that there was not evidence of that presented. And so why isn't that fatal to any effort to invoke plain anyway? I mean, even if plain is retroactive and even if you can invoke it now.
Well, I understand the court's concern with that issue, but again, my position would be that they're different analyses that the court would look at that claim to begin with.
But both analysis require a Durant. The Durant analysis, substituting Plain for Jones. I mean, that's how you argued the case.
That's true. I mean, the Durant analysis does require the petitioner to make a showing on those three different issues. But I don't think that the court's conclusion as to one of those issues would necessarily make the whole claim res judicata.
Was this raised in the district court at all?
It was not.
Well, so was it fleshed out what the elements of an equal protection claim might be or a due process claim? Was that fleshed out in the district court?
Well, that's part of the problem, Your Honor, and that's why I wanted to briefly discuss the procedural history. Basically, what happened was the applicant filed a pro se application. The state filed a motion to dismiss, arguing res judicata, arguing statute of limitations, and then the district court entered an order setting that motion to dismiss for hearing. And then when the parties showed up to the hearing, I believe that the applicant's counsel was present by telephone. When the parties showed up for hearing, then the court went right into the analysis as to whether Plain was retroactive or not. And that wasn't an issue that was actually briefed by the parties in either the motion to dismiss or in the resistance to that motion to dismiss. The court just went right into that. But
it is you would agree it's a pure legal issue, right? Whether it's retroactive or not.
I would agree that it's a pure legal issue, but I would also maintain that it would be something that would be outside of the pleadings and something that the district court could not properly consider during the hearing.
I tend to agree with your characterization of what happened in the district court. I guess my question is, it's now before us, it's now briefed. It's a pure legal issue. It was the basis for the district court's decision. Is there a reason why we can't decide it now?
Well, I think that if this court looks to the 2013 case of Wynn, which I cited in my brief, it's a very similar case in how it comes to the court. In fact, the remedy that the court ordered in that case was to remand for further briefing of that issue. And that decision ordered that remedy despite the fact that there was already law on point as to that issue. The court had decided in Heemstra that the nature of the relief was prospective only, and then in Guzman, the court confirmed that. But nevertheless, even though the issue was properly before the court in Wynn, the court still remanded the case for further proceedings so that the parties could brief that. Now, to the court's question as to why that would be proper in this case when the parties have had a chance to brief the issues, there are certain arguments that I would potentially be restricted from arguing on appeal that weren't raised below. And for instance, one of the cases that the state cited in its routing statement didn't get into much in the briefing, but it's cited in the state's routing statement in its brief, is a case called Thongbon, I think is how you pronounce it. And that's a case that is extremely similar to this, the Court of Appeals.
Can I interrupt you for a second? As I read the state's motion to dismiss, they raise res judicata because they cite section 822.8 of the code, which says once it's been raised in a prior proceeding, you can't raise it in a subsequent proceeding. And you did raise the Duran test in the prior proceeding. And that state actually raised it. I mean, I don't know why didn't the state raise it by citing Code Section 822.8 in its resistance?
Why didn't the state raise it?
Yeah, you answered Justice Apple's question that they didn't raise res judicata below.
Well, at the motion to dismiss hearing, the court basically wasn't interested in hearing anything other than whether Plain was retroactive or not. They didn't get into arguments as to whether res judicata applied, whether...
Appeal, we could affirm on any ground raised down below, whether it's not. So, I mean, is it in play or isn't it in play?
Well...
Regardless of the merits of it, is it in play?
I mean, I think that, as the court said, that the court could affirm on any basis that it could find in the record.
Well, this is the fourth PCR, correct?
That's correct.
I mean, don't we have an interest in finality and that would be undermined by relitigating issues that were raised and decided before?
I think we do, but there's something that's unique about the Iowa post-conviction statute, and that it doesn't have a separate mechanism for successive petitions. It doesn't have certain hurdles that a defendant or an applicant has to overcome in order to get a second, third, fourth bite at the apple. And that's something that I think that the legislator has to fix because the second, third, and fourth petitions are treated essentially as the first, as long as it's...
Wait a minute, though. I think in the Jones case, and I invite you to correct me, but in the Jones case, there was a holding that you failed to show systematic exclusion. All right. Now, you rightly say that you raised different claims here. The Jones case involved fair cross-section claim. You now raise separate claims of equal protection and due process, as I understand it. But the question is, if there is a finding that there is no systemic exclusion, do you have an equal protection claim or a due process claim? In other words, what are the factual underpinnings required for equal protection and due process that weren't decided in the Jones case? That's what I'm fishing for.
Well, I think that's a valid point. The court has considered this issue, but I still maintain my position is that res judicata doesn't apply.
You may be right on res judicata, but there may be issue preclusion is where I'm going. I mean, I think you're right on maybe res judicata if we want to do a vocabulary challenge here. But on issue preclusion, if there's been a finding that there is no systemic problem here, does that issue preclusion prevent you from bringing an equal protection claim or a due process claim?
Well, I think that's something that the court's going to have to decide.
But for equal protection due process claim based upon the retroactivity of Plain, aren't you out?
Again, I don't think that is our position. And
why aren't you out? Explain that to me.
Well, I think that by out, what could the court clarify with?
Well, you're out. You under 822.8, which is sort of maybe it's more of an issue preclusion. It says once it's raised one time, you can't and adjudicated, you can't raise it again. It's sort of a little broader than issue preclusion or res judicata. But why aren't you out under that statute?
Well, Your Honor, I do think, and I don't think that this is really a matter of semantics. I do think that issue preclusion and res judicata are different legal concepts, and the state, in its motion to dismiss, argued res judicata and not issue preclusion.
They ordered 822.8, which is sort of a hybrid of both.
Well, I think that it's up to the state in its motion to dismiss to specify, with enough notice to give to the moving party as to what their grounds are for dismissal.
They cited all the prior post-conviction relief action, and they attached the case to it. What more do they have to do?
Well, their motion to dismiss was one single page, and almost all of it was the procedural history of the case, with a couple cites to statutes, but no specific language as to what they were pointing to as grounds for dismissal.
May have been only one page, but it does cite 3 prior PCRs, and embedded within those PCRs is a lot of information. Can't this court consider that?
Yes, the court could consider that.
Including the findings of why those cases, or how those cases were resolved?
Yes, I think that those would be incorporated into this PCR petition and this action.
And in one of the...
Thank you.
Mr. Nieman, thank you. Ms. Soich, you may present your argument.
Good morning. May it please the court, counsel. I am Soich, and I represent the state. Your Honors, with regard to the res judicata issue preclusion issue, the state maintains it is absolutely decided the issue of systematic exclusion. And I'm aware that the court is looking at the idea that is an equal protection claim or a due process claim different than the original Duren versus Missouri claim or the Plain claim, but any claim based on that equal protection or due process argument has to emanate from the original Duren versus Missouri claim, and the disparate treatment between those who have raised it, those who have not raised it, or those on collateral review, those on direct appeal. And I don't think it,
I mean, you're saying that the fair cross-section claim is identical to equal protection?
I'm not saying it's identical, Your Honor, but I'm saying it starts there. You have to, it's based on the Duren versus Missouri claim.
And I don't know the answer to it, but if there is a different factual predicate for equal protection than a fair cross-section claim, or a different factual predicate for due process than fair cross-section, the claim would be alive. And I was posing the question to other counsel, and I pose it to you. Is it true that we have merger of claims that there's no distinction between a fair cross-section claim and an equal protection claim and a due process claim? That strikes me as kind of extraordinary. But
I think there is a distinction, Your Honor, between the claims, but I think the due process and equal protection claims are sort of or I should say it the opposite way. The Duren versus Missouri fair cross-section claim is sort of embedded in those other claims.
not only is it embedded, it forecloses the other claims, I think you're arguing.
Yes. And this court, in terms of general res judicata issue preclusion claims, has often said that you can't sort of dress up one claim in another claim's clothing. We look to the real crux of the claim to see if it has actually been decided adversely to a defendant before. And as I understand this defendant's argument, there's really no equal protection or due process claims now. It's really much more just a straight-up Duren v. Missouri plain retroactivity argument. That's really...
Let's assume that the due process and equal protection claims were separate. How would those claims get around the time bar? Because there's no new law on those two issues. As I understand it, the argument is plain is new law, therefore the defendant gets around the time bar.
Right, Your Honor. And if plain is not new law, then the time bar of 822.3 absolutely does apply, so that he would not be able to get around the time bar. And the state has made the argument in this case that the time bar should not be interpreted in the same way as the Heemstra-Wynn line of cases, that really this is a different sort of claim, that when Plain overruled Jones, it was really a different kind of overruling than the Heemstra-Beeman issue. And that someone could have...
I mean, frankly, Jones was a very sweeping opinion. You had to show absolute disparity, and it was cited 40 times thereafter. And you know the history of all this. And the problem with the absolute disparity in Iowa, of course, was you could never prove it. And for 40 occasions, we kind of went boom, 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 boom. Now, it's a new day, and you can show disparate treatment through other means, and we've worked it out in subsequent cases, as you know. But that strikes me as a fundamental change in our approach to fair cross-section claims.
But, Your Honor, it wasn't a fundamental change in the way that Beeman and Heemstra was, because in Heemstra, the court realized that it had been presented with this claim over and over and over and over again and rejected it every time. I would submit to you...
Oh, sure we had. I'm sorry to interrupt you, but in the absolute disparity, they pound, 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 I mean, and we said no, did we not? I mean, am I mischaracterizing?
I don't think there was much activity, maybe initially after Jones, Your Honor, but once this court had an opportunity, then I think everyone sort of accepted it, even though it was obvious.
But isn't that the point? I mean, I mean, I understand your argument that plain is like Teague, and therefore it's that kind of a situation. Therefore, it shouldn't be retroactive. But it seems to me you're really, paddling upstream, just try and say that it wasn't new law. I mean, before plain came along, the absolute disparity rule really made it pretty much impossible to show underrepresentation of a systemic underrepresentation of a minority group in a jury pool, didn't it?
It did, Your Honor, but the first time that someone came to this court and really said in recent time, you need to change it, this court very easily, I think, changed Jones in the plain decision to say, you're right, this was never a law that could have really been used by a minority in Iowa. So I'm just saying it was more ripe for the picking. But that, even if the court rejects the idea that the 822.3 new law argument, even if the court says plain is absolutely new law, and I would submit that Jones and Lilly really are much more new law than plain, and we're in kind of an odd procedural posture here today because we are arguing about the retroactivity of plain when, as the court knows, really the law now is Lilly and Veal and Williams. It's not really plain anymore. So we're in kind of an odd spot, I think, to be talking about plain, but that's the claim that we have, is plain retroactive. So even if the court does not accept the state's argument about 822.3 new law.
What about the argument here that the applicant makes that, they were ambushed in the district court, that they didn't know that retroactivity was going to be an issue at the hearing on the motion to dismiss? Can we nonetheless proceed to rule on retroactivity?
I think absolutely, Your Honor. First, I don't think they were completely ambushed because in the amended post-conviction action, they talked about state versus plain and the retroactivity of state versus plain, or that state versus plain would be at issue at the very least. And the court, I will agree with you, Your Honor, that the court essentially cut to the chase. Judge Stigler said at the very beginning of this hearing, the issue is whether plain is retroactive. And that is true. And I realize that defense counsel at least initially said, wait, Your Honors, can we talk about the new ground under 822.3 first and leave the retroactivity for the next hearing or for another day? But, Your Honors, there was nothing that could have been decided other than that plain was retroactive that would have helped this defendant. That's the only way this defendant could win with his 2008 conviction, his 2010 procedendo, his 2013 expiration of 822.3. That's the only way he could win is if plain was retroactive. So did the court sort of jump to the ultimate conclusion? Absolutely. Could another court maybe have given him a chance to do it sequentially in a couple of hearings? I guess so, but that really isn't the question here. Now, as the court has sort of alluded to, we are here, we're talking about the retroactivity, and this court should absolutely find that plain is not retroactive. And that's what the court said, you want your appellate issue, you have your appellate issue, I'm saying it's not retroactive. So the court should decide that now because the issue is before it, and the issue has been briefed, obviously, and we would say clearly, if you look at Teague versus Lane not only for the general framework, as you usually do, but for the very specific framework of cross-section, fair cross-section claims. Teague versus Lane says this does not fall into that exception.
Yeah, it does say that. One wonders why.
Well, Your Honor, I think it... Oh, I'm sorry. Go ahead.
Well, reliability is at stake, of course. The reason why we want fair cross-section is to get a full view of the community, and the empirical studies show that it matters.
Your Honor, might I push back a tad on the empirical study?
Push back all you want, please.
In plain, the court obviously cited the Anwar Duke University study. And in that study, the court looked, or the commentators, rather, the authors looked at the disparate rates of conviction between white defendants and black defendants when we had an all-white jury. In the study, the court, I'm so used to saying the court said everything, I can't say anything else. The authors said that with white juries and white defendants, there was a 66% conviction rate. With black defendants, there was an 81% conviction rate. So there is a disparate effect. In plain, this court cited that study to say that that shows that it does have an effect. And that's true, Your Honor, but what the court didn't go on to say is in that very study, pages 1035, I think, and 1046, the authors said, if there's just a person of color, because they said those numbers equalize, the 81 and the 66% equalize when we have at least one person of color on the jury. But what the study went on to say was when we have just one person of color on the pool, that makes a difference, and they also equalize when they're just on the pool. So I think it goes too far to say that we always need a person of color on a jury. Obviously, that would be ideal, but especially in a homogeneous state like Iowa, we can't always do that. We can try. It's certainly an aspiration that we all should attempt to implement, but it's just not something that
Let me ask you this question, building on it. Supposing, except for purpose of this question, that reliability is a reason for fair cross-section. A reason. Does that mean it's retroactive?
No, I don't think it does, Your Honor. Reliability may have, I guess to take the premise of your question, you're saying it absolutely affects each.
I don't say it absolutely affects. Actually, the purpose of I'm asking you to accept the premise that the purpose of fair cross-section is to promote reliability of jury verdicts, and just assume that is a correct premise. I understand you're kind of challenging it, but assume it's a correct premise. Where does that leave you in the retroactive analysis?
I think that the retroactive analysis has an extraordinarily high bar, and I don't know what would actually satisfy that bar. I think the court in Sheryl and other cases has said, we don't know what would satisfy that. We haven't seen it. Maybe the mob violence, maybe knowing use of perjured testimony, something like that. But the court in Teague, and I understand you may not agree with the court in Teague, but this court in Brewer, the Court of Appeals in Thongvan all said that really the idea of a homogeneous jury doesn't impact the fundamental fairness of the verdict. And to give you an example of that, Your Honor, we could have someone who made a Duren claim, made a successful Duren claim, showed all three factors, went back, say that then the case was sent back, that defendant could get the exact same panel that he got the first time because of chance, because there weren't the various people in the jury, on the jury pool, that were representative. So it really doesn't do anything specific. It's, of course, the goal. Again, I understand that it's the goal.
Ask a question about the practical issues. I mean, here Mr. Jones was convicted in 2008. So if we were to hold that plain is retroactive and people can bring plain challenges to a conviction 2008 or earlier, they would then be wanting to find all these jury pool records and jury selection records that are a decade or more old. Do those records even exist anymore?
That's a very good point, Your Honor. I don't think that they necessarily do. I know that 607A says that the jury manager should keep records now for 4 years, or if the chief judge says longer. But we are going back, and I think that's the reason why we shouldn't make plain retroactive. The scope of this and the logistics would just make it ill-advised. And in terms of the scope, Your Honors, I'd like to point out that, and I apologize to the court, I perpetuated the error in the plain decision about being a member. Obviously, you don't have to be a member. That does find its way in the plain decision, though. You don't have to be a member of the class that you're, the group that you're claiming is underrepresented. So to that point, anybody could make a plain claim if you found that it was retroactive. A white person could argue there were not enough Pacific Islanders. A Hispanic person could argue there were not enough African Americans. So it would apply to every defendant, because every defendant could conceivably make a plain challenge, number one. Number two, as you say, Your Honor, the records, I can't imagine how difficult it would be to find records that go back 20 or 30 years on the ethnicity or the race of jurors.
Then the claim fails. I mean,
but Your Honor, why open that up when it's so difficult to prove logistically and tax the system like that if we know that really people aren't going to be able to prove the claim? Another reason I think it shouldn't, I see that my time is up, Your Honors. We ask that you find plain is not retroactive. Thank you.
Ms. Soich, thank you as well. Mr. Nieman.
Thank you, Your Honor. This court stated in U.S.
Before you start, in your brief, you raised a due process argument that you were sort of, hoodwinked at the hearing because you ruled on retroactivity, not on the issues that the state raised. Tell me in your best, simplest words, what basis do you make a due process or equal protection argument on outside of plain, other than you were hoodwinked at the hearing?
Well, Your Honor, are you asking with respect to the substantive claim or procedural due process?
Well, you make the due process equal protection. I want to know what they are because I'm having trouble finding it in your brief, other than you made the hearing was supposed to be on one grounds and the court ruled on another ground. Are you making any other due process or equal protection claim? And if you are, what is the substance of that claim outside of plain?
Well, Your Honor, there's essentially two arguments that are in the brief. The first is that the court, I guess, hoodwinked, as you would say, ambushed. Yeah, they took the applicant's lawyer by surprise, and frankly, the state as well, and went to an issue that wasn't supposed to be decided at that hearing. And then there's separately the underlying claim that the applicant makes in his application as to his due process rights being violated as a result of an unfair representation in the jury pool. So
that's a plain argument. So your due process argument is based on a Durant test. Because even if we apply plain, you still have to apply the Durant test.
That's part of it.
What's the rest of it that's not associated with plain or Durant?
Well, the way that the claim is characterized in the application is under due process, equal protection. I think that there might have actually been a third ground, but it's mostly due process and equal protection.
I understand you could call it anything you want. I want to know what the basis of the claim is outside of plain and Durant. If you have anything. If you don't, you don't.
It is a plain claim.
Should we decide this narrowly or broadly? Aren't there other cases out there that are this issue is going to keep coming up until we answer it, right? And if it seems to me it's an exercise in futility to send you back down on the time bar or the race judicata, some other issue. If at the end of the day, your client wins only if plain is retroactive. Why don't we answer it now, broadly?
Well, Your Honor, I think that there are better cases that are currently pending that are a better vehicle for that.
Is there?
It's the same legal issue. Why are they a better vehicle?
Because they don't contain issues with respect to res judicata, with respect to how the motion to dismiss was decided. They're basically cleaner vehicles for that. And one case that I specifically want to bring up that, again, was cited in the state's brief is the Thongbon case. And the one reason that I want to bring it up is that the petition for further review is pending now before the court. And I imagine that it's still pending because the court has this case pending before it. But what's different about this case is that there's a different retroactivity analysis that defendant applicant uses, and that's based on Iowa's state constitution. And they are arguing that there could be broader protections in the Iowa state court constitution as reasons for finding plain retroactive.
Is there any set of circumstances in which your client can prevail without holding plain as retroactive?
Well, I mean, to be fair, or to be clear, the relief that we're asking for is for it to be remanded for further
I understand that.
briefing.
On the substantive claim to entitle your client to post-conviction relief, is there any set of circumstances where your client can prevail without the court holding plain as retroactive?
I do not believe so. And I see that my time is up. I thank you very much, and we would ask that the court reverse and remand. Thank you.
Mr. Nieman, thank you. Nieman, thank you as well. And Ms. Soich, thank you again. Case of Jones versus State is now then submitted, and we'll next hear the arguments in Karen versus Elliott Aviation.